Welcome to Thinking Deeper by 6-7. Today, we are cracking open a dense, centuries-old legal text that governs a society known for its secrecy. We're talking about Masonic law.
And this is an abstract philosophy. This is the operational statutes, the nuts and bolts of how these lodges actually run.
Exactly. And we're going to dive into the core idea. What happens when an institution has two kinds of law, one written and one unwritten and supposedly unchangeable? We're talking about the absolute power of one man, the Grand Master, versus the absolute veto of a single member and the one thing that can bar a man forever.
A lack of belief in God. The absolute rejection of the atheist is, you could argue, the cornerstone of this entire legal framework.
So Mackey's 1856 text, The Principles of Masonic Law, wasn't just a collection of old rules, was it? He had a bigger mission.
Oh, absolutely. He saw that different Grand Lodges were making contradictory decisions, based on local biases or just inexperience.
So he wanted to create a kind of legal textbook.
A methodical treatise. Something based on abstract principles, like Blackstone did for English common law. He wanted any Mason, even the Grand Master, to understand the boundaries of their own power.
Recognizing that they are, as he put it, not infallible. So let's use his framework to map this entire legal landscape.
To really get it, you have to start with the fact that Masonic law is, it's dualistic. It's a lot like English or American law in that way.
Meaning there are two distinct types of law operating at the same time.
Exactly. And you have to understand the difference in their weight, their authority, to understand anything else.
Okay, so let's start with the bedrock, the unwritten law.
That's what's called the lex non scripta. It's not law from a book or a statute. It's law from, well, ancient usage. Customs, traditions, things that have existed from the remotest antiquity and are just accepted by everyone.
It's the common law of the craft. The rules everyone just knows.
Precisely. It's the foundation, and then on top of that you have the written law.
The lex scripta.
Right. And that comes from specific historical documents. Things like the ancient Masonic charges or regulations passed in, say, 1663, or even the questions asked when a master is installed.
But, and this feels like the whole game right here,
Huh?
the written law can never, ever contradict the unwritten law.
Never. That's the absolute limiting clause. A Grand Lodge can make new rules, sure, it can change old ones, but it comes with a huge asterisk, provided always that the old landmarks be carefully preserved.
So these landmarks are the unwritten constitution.
And Mackey is crystal clear on this. No man, no group of men can make any alteration or innovation in the body of Masonry. Those landmarks are fixed points. Everything else has to revolve around them.
To understand that authority, we should probably look at how it was organized, because the current structure is actually not that old. It all changed in the early 1700s.
Right. Before 1717, the supreme governing body was something called the General Assembly of Masons.
And it was radically different from a modern Grand Lodge.
Completely. It was, for all intents and purposes, a direct democracy. It was open to every member of the fraternity. If you were a Mason and you could get there, you could vote.
So the youngest apprentice had the same right to show up and legislate as the most experienced master.
In theory, yes. It was a gathering of the entire craft. And lodges themselves were more informal. You didn't necessarily need a formal warrant from a higher body to meet.
Okay, so what happened in 1717 that blew up that whole system?
Well, they adopted a new model. The General Assembly was transformed into a strictly representative body.
So the individual members gave up their right to vote directly?
They did. They voluntarily vested that power in the masters and wardens of their local lodges. From that point on, the new Grand Lodge was made up of delegates, not the entire population of Masons.
That is a massive political shift, a willing surrender of individual power to a representative system.
It is. But you can see a little echo of that old right, even after the change. There was a regulation in 1721. It's fascinating. It said that any proposed changes to the constitutions had to be shown to all the brethren for their perusal.
All of them?
Even of the youngest entered apprentice, before dinner at the big annual meeting.
Wow. So even though they couldn't vote on it anymore, there was still this formal acknowledgement that the authority ultimately came from them.
Exactly. It was a symbolic tip of the hat to that ancient democratic right. But Mackey is quick to point out that this rule pretty quickly fell into disuse.
It became obsolete. The representative system just took over completely.
It did. The Grand Lodge became the legislature and the judiciary, and that was that.
So if that's how the first Grand Lodge was formed, how does the law handle creating a new one, let's say in a new territory? Can a bunch of Masons just get together and declare themselves a Grand Lodge?
Absolutely not. It's legally prohibited. The process has to be organic, meaning You have to have subordinate lodges first. The Grand Lodge grows out of them. They are the source of its legitimacy. A mass meeting of Masons has no authority to just create a sovereign body out of thin air.
Okay, and there was a debate, wasn't there, about how many lodges you needed? Some said 4.
Yeah, that was a real sticky point for a while.
Yay.
A text called the Ahiman Reason insisted on 4, but that was more of a competing factions rulebook.
The original Book of Constitutions didn't actually say that.
No, it just stated as a fact that the first Grand Lodge was formed by 4 lodges. It described what happened. It didn't prescribe it as a rule for all time.
And this is where American practice actually set the legal precedent.
It really did. Most American Grand Lodges did form with 4 or more. But then you had the Grand Lodge of Texas, formed in 1837.
With how many?
With only 3 subordinate lodges. And because it was immediately accepted and recognized as a legitimate, regular Grand Lodge by all the others, it basically settled the argument.
So 3 is the minimum, if necessary.
That became the accepted legal precedent. And then there's one final step to make it all official.
The subordinate lodges have to surrender their old warrants.
Correct. They hand back the charters they got from their original Grand Lodge, and then they accept new ones from the Grand Lodge they just created.
It's a formal transfer of allegiance.
It's the final act that vests all authority in that new sovereign body. It establishes a clear, unbroken chain of legal command for that new jurisdiction.
Okay, so we've built the pyramid from the bottom up. We have the members, the lodges, and the Grand Lodge. But the paradox of Masonic law is that this whole representative structure seems to exist to elevate one single figure to the top.
The Grand Master.
Who is he in a legal sense, and why is his power so, so absolute?
The office itself is considered essential. It's existed as long as the institution has. He is the presiding head, but his power is far more than just, say, a chairman or a president.
And the most jarring example of this, the part that just seems to fly in the face of a representative body, is the rule about appeals.
That there are none.
You mean there is no appeal from a decision of the Grand Master to the Grand Lodge itself?
That's right. His ruling is final. Even if the entire Assembly of Representatives disagrees with him, it's settled law based on ancient usage.
Wait, I'm stuck on that. If the whole system evolved from a direct democracy, the General Assembly, how can one man who is elected by that body be completely immune to its review? That sounds like a contradiction.
It does. It sounds like a huge one. And people at the time recognized that. Mackey quotes a Maryland committee from 1849 that called it an anomaly at war with every principle of Freemasonry.
So what's the justification?
The defense is rooted in necessity and dignity. He is the consecrated head of the entire craft. To allow his subordinates, which is what the members of the Grand Lodge are in a judicial sense, to question and overturn his authority would be
Subversive.
subversive. It would undermine the discipline needed to govern. The idea is that his decision, even a bad one, has to stand in the moment to preserve the integrity of the office itself.
That's putting an enormous amount of faith in the character and judgment of one individual. What if a Grand Master abuses that power? If he's malicious or just plain wrong, is there truly no recourse?
There is. But it's a mechanism so difficult and cumbersome that Mackey himself admits it basically makes the Grand Master immune. The only real punishment is his own conscience or the loss of respect from his brothers.
So what is this forgotten mechanism?
It's buried in that old 1721 regulation we talked about. If a Grand Master abuses his power, you can't just impeach him. You have to propose a new regulation specifically for his punishment.
Okay.
And to get that passed, it has to be proposed, then formally agreed to 3 months later at the next meeting, and then it has to be presented to all the brethren down to the youngest apprentice at the annual feast. And only then, if a majority of everyone present approves, does it pass.
So you would need a massive, sustained, nearly unanimous consensus across the entire jurisdiction for months on end just to even bring it to a final vote.
Exactly. It's a procedural fortress. It's designed to prevent any kind of impulsive, politically motivated action against the leader. Stability of the office is prioritized above almost everything else.
Incredible. Okay, let's look at his active powers. The dispensing power seems to come up a lot.
A dispensation is just what it sounds like. An exemption from a rule. But, and this is key, he can only grant dispensations from the written law, the lex scripta. He can never, ever dispense with an ancient landmark.
What's a common example?
The most famous one is allowing a lodge to make more than 5 Masons at one time. The normal rule is 5, to ensure each candidate gets proper attention. But in a case of urgent necessity, like a new town booming in population, the Grand Master can dispense with that rule and let them initiate, say, 10 men.
And he also has power over filling vacant offices.
He does, but it's limited. If a master of a lodge steps down, the wardens have an inherent right to succeed him. The Grand Master can only issue a dispensation to elect a new master if those wardens refuse to serve. His power kicks in to fix a problem, not to override the existing rights of others.
His most important power, though, seems to be in creating new lodges.
It is. While the Grand Lodge issues the final permanent charter, the warrant of constitution, it's the Grand Master who grants the temporary warrant of dispensation that lets the new lodge start working. And he or his deputy must personally conduct the ceremony that officially constitutes the lodge. He literally breathes life into it.
Which brings us to the most legendary, almost mythical power he has. The ability to bypass the entire system, making Masons at sight.
The ultimate prerogative.
What does that actually mean, to be made at sight?
It's a technical term. It means the Grand Master has the power to personally initiate, pass, and raise a candidate, skipping the whole petition, investigation, and ballot process of a local lodge.
How does he do that? Does he just show up at a lodge and say, initiate this man?
No, he convenes his own temporary lodge, called an occasional lodge or a lodge of emergency. He gathers the necessary number of Master Masons, opens this temporary lodge for the full purpose of conferring the degrees on that one man, and when the work is finished, the lodge ceases to exist.
That is the biggest possible end run around the democratic process of the lodge. How on earth is that justified?
Well, historically, it's all over the old records. The Book of Constitutions cites examples. In 1731, the Grand Master, Lord Lovell, did it for the Duke of Lorraine. In 1766, Lord Blaney did it for the Duke of Gloucester. It was a known and accepted power.
And the legal logic behind it.
It's what's called an a fortiori argument, a from the stronger argument. Meaning, if the Grand Master has the undisputed power to give 7 other men permission to make Masons by granting them a dispensation for a new lodge, then he must certainly have the power to do it himself in his own presence.
If he can delegate the power, he must possess it himself.
Exactly. But even here, he's bound by the landmarks.
But he can't just snap his fingers and declare someone a Mason.
Absolutely not. He cannot dispense with the ceremonies, the rituals, the oral laws. He still has to perform the full, proper initiation with the help of the other brethren in that occasional lodge. He can't just communicate the degrees by saying they're conferred. The work must be done.
And this was usually reserved for special candidates.
Almost always. It was often used for royalty, princes of the royal family.
Yeah.
For reasons of state, they weren't going to go through the months-long petition process of a local lodge and be subjected to a ballot like a commoner. This power allowed the institution to bring in the highest echelons of society without compromising the ritual itself.
We've just covered the almost monarchical power at the top, but now the whole system flips on its head. We're going down to the power held by a single anonymous brother in a local lodge.
The gatekeepers. And the gates are protected by enforcing 4 types of qualifications for any candidate.
Moral, physical, intellectual, and political. And Mackey is clear that these aren't just arbitrary suggestions, they are legal requirements.
Yes, and the moral qualification, specifically the religious test, is without a doubt the most fundamental. It's the brightest line that Masonry draws.
Let's focus right there. What is the absolute non-negotiable spiritual requirement to become a Mason?
The first charge is that a candidate must obey the moral law. Historically, that's understood as the 10 Commandments. But the core test, the one that cannot be waived, is that he must be free from the great error of atheism or a belief in no God.
That language is absolute, uncompromising. So a man could be a paragon of every other virtue, honest, charitable, a good citizen, but if he is an atheist, the door is permanently closed. Why?
The reasoning is purely legalistic, and it gets to the heart of the entire Masonic structure. The fraternity binds its members together through solemn oaths and obligations.
Okay.
What is an oath? An oath, by definition, is an appeal to a higher power, to God, to witness the truth of your promise. It's a contract between you, your brothers, and your maker.
And if you don't believe in a maker?
Then the appeal is meaningless. The oath has no binding force. In the legal view of the institution, an atheist is a person who is incapable of making the solemn promise that undergirds the entire fraternity. Admitting an atheist would be like building a house on sand. It undermines the very foundation.
So it's not framed as religious intolerance, but as a kind of contractual necessity.
That's precisely the argument. It's a legal requirement for the security of the institution itself.
This seems to create a strange situation, though. We know Masonry is famous for its religious tolerance, accepting Christians, Jews, Muslims.
And that's the genius of the compromise that was struck in the 18th century. Originally, Masons were charged to be of the religion of their country. But as the fraternity became more universal, that had to change.
So they found a common denominator.
They did. The new requirement was that a Mason must adhere to that religion in which all men agree.
Which means?
A belief in a supreme being, a God. That's the floor. But there's no ceiling. So you successfully exclude the one person who can't take the oath, the atheist, while creating a broad tent for anyone from any monotheistic tradition. Once a man is in, his specific opinions are his own business. But that belief is the price of admission.
And this moral gatekeeping extends beyond just belief.
Oh, yes. The candidate can't be an irreligious libertine. They have to be good and true men of good report. Mackey is adamant that letting in immoral men is the single greatest injury you can do to the order.
Okay, let's move to the second gate, which is often the most controversial today. The physical requirements.
Yes. Candidates must be men of legal age. But the key is the rule of perfection.
Which states?
That a candidate must be upright in body. Not deformed or dismembered, but with hale and entire limbs, as a man ought to be.
Mackey takes a very hard line on this, doesn't he? He says, perfect is an absolute. There are no degrees of imperfection.
His argument is jurisprudential. It's a slippery slope. The moment you say, well, a missing finger is okay, where do you draw the line? The old rule from 1683 said he must have his right limbs. The phrase about no maim or defect that may render him incapable isn't a functional test.
You mean it's not asking, can he still do the work?
No, it's read as there can be no maim or defect because any such defect renders him symbolically incapable.
Symbolically. So this isn't just about being able to give the handshakes or make the signs.
That's the practical side. But the deeper speculative reason is all about symbolism. Every Mason is meant to be a symbolic perfect stone or a perfect ashlar to be used in the building of a spiritual temple. A flawed stone can't be used. A physical defect in the man destroys the integrity of that symbol.
I know this rule came under pressure. A spirit of expediency, as Mackey called it. People wanted to admit good men who had been, say, injured in war.
They did, and it created a huge tension. But for the most part, the landmark held. Mackey cites decisions from New York, Maryland, his own Grand Lodge in South Carolina, all of them standing firm.
What was their reasoning?
The New York Grand Lodge put it best. They said the moment you make one exception, the landmark is broken. You have no legal ground left to reject anyone. They pointed to a case in Mississippi where a blind man was initiated as the ultimate example of where that road leads. The principle had to be absolute to remain a principle at all.
Just as rigid as the moral gate. Okay, let's quickly touch on the other two, intellectual and political.
Intellectually, it's pretty straightforward. He can't be a fool or a madman. But there's a subtler point. While no law explicitly said so, the spirit of the institution implied he should be able to read and write. Because Masonry presents itself as a science. It discusses geometry, architecture, the liberal arts. If a man is illiterate, he can't study the constitutions, he can't read the histories, he can't fully engage with the intellectual side of the craft, he can't avail himself of its teachings.
And finally, the political qualification. He had to be freeborn.
Right. This excluded slaves or anyone born into bondage, even if they were later freed.
And the reason for that?
On a practical level, it was to ensure that a member was his own man, not subject to the whims of a master who could compel him to reveal secrets or act against his will. It was about ensuring true free will and independence.
Mackey even traces this idea back to a biblical story.
He does. He links it to the tradition of Abraham and Ishmael, where Ishmael, as the child of a slave, was excluded from certain rights. So it's a rule with deep, ancient, almost theological justifications, all aimed at ensuring the lodge is made up of men who are truly masters of themselves.
Okay, that brings us right to the door of the lodge. The candidate has been vetted. He meets all 4 qualifications. Now we get to the process where the Grand Master's authority means absolutely nothing.
And the power of a single member means everything. We're talking about the ballot.
A process that is intentionally slow and deliberate.
Extremely. A petition comes in at one meeting. A committee is appointed to investigate the man's character. They report back at the next regular meeting. Only then can a vote be held.
And that vote is governed by the unanimity landmark.
It is. The rule from 1721 is still law. It requires the unanimous consent of all members present to accept a candidate. This is considered an inherent privilege of every member.
So inherent that not even the Grand Master can issue a dispensation to get around it.
Not him. Not the Grand Lodge. Nobody. And the tool for this is the ballot box. with its white and black balls.
Where the secrecy is everything.
It's absolute. You can never be asked why you voted the way you did. You answer only to your conscience. That secrecy is what guarantees the complete independence of the voter.
So one black ball stops everything. Can that ever be undone? What if someone made a mistake? Or if a member cast a black ball out of personal spite?
A motion to reconsider a rejection is always, always out of order. Once that ballot is declared foul, it's over.
No exceptions.
Well, one very narrow one. If the master of the lodge himself has a doubt, maybe he thinks a mistake was made, he can immediately order a second ballot. But it has to be done right then and there, on the same night, and only if every single person who voted the first time is still in the room.
So the window to fix a potential error is incredibly small.
Tiny. It emphasizes the finality of the vote. It is the ultimate democratic check on power in the entire system.
So a candidate is accepted, he's initiated. But moving through the degrees isn't automatic, is it?
Not at all. Masonry is described as a progressive science.
And that requires
Time, patience, and a considerable degree of application. Before you can advance to the next degree, you have to prove suitable proficiency in the one you're in. That usually means an examination in open lodge.
And there are rules against rushing candidates through.
Oh, yes. Mackey calls it the penalty of speed and says it's a great injury to the craft. It creates ignorant members who don't understand what they've joined. Many Grand Lodges mandated a minimum time between degrees, like 4 weeks, to force a period of study.
Let's clarify the difference between being a Mason and being a member of a lodge.
A crucial distinction. The initiation makes you a Mason for life. You are bound by those obligations forever. Signing the lodge's bylaws is what makes you a member of that specific organization.
And being a member gives you rights, like the right to visit other lodges.
It's an irreversible right for any member in good standing. The ancient rules say you must receive and cherish strange fellows. But that right comes with very strict security protocols.
This is where the legal maxim gets turned on its head.
Completely. In civil law, it's better that 10 guilty men go free than 1 innocent man suffer. In Masonry, the maxim is reversed. It is better that 99 true men should be turned away than that 1 Cowan should be admitted.
A Cowan being an intruder or imposter?
Exactly. The security of the lodge's secrets is paramount. So any visitor has to undergo a strict examination. And if there's the slightest doubt, he is denied entry. No chances are taken.
What about Masons who leave their lodge? The unaffiliated, do they lose everything?
They lose their connection to the organization. They forfeit the right to visit, the right to financial aid from the lodge, and the right to a Masonic burial. It's strongly discouraged. Every Mason ought to belong to a lodge.
But they're still Masons.
Yes, they are still bound by their obligation of secrecy, and critically, by the obligation to help another Mason in imminent peril. That duty never goes away.
Let's end this section by circling back to the theme of the moral qualifications, but in the context of Masonic trials. Who is allowed to be a witness?
This is where it gets really interesting and ties everything together. In a Masonic trial, the testimony of an atheist must be rejected.
Even if he saw the whole thing, what's the legal reasoning there?
It's the exact same reasoning as for rejecting him as a candidate. An oath requires a belief in God to be binding. Since a witness in a trial must give testimony under a solemn obligation, and an atheist is considered incapable of feeling that obligation, his testimony is legally inadmissible in a Masonic court.
So we have this incredible loop. A man is barred from joining for being an atheist, and then if he witnesses a Mason committing a crime, his testimony can't be used against that Mason in a lodge trial.
That's the paradox. But, and this is a critical distinction, the testimony of profane witnesses, meaning non-Masons who do believe in God, is generally allowed.
Why is that distinction so important?
Because the goal is to find the truth and protect the moral character of the lodge. Mackey gives a powerful example. Imagine a Mason is convicted of theft in a public court, based on testimony from non-Masons. If the lodge then refused to accept that profane testimony and acquitted him on a technicality, what would that look like?
It would look like the lodge was protecting a known criminal.
Exactly. A disgraceful spectacle. It would bring the entire institution into disrepute. To protect its own integrity, the lodge has to be able to accept truth, no matter the source, as long as the witness is competent to take an oath.
And the ultimate punishment, expulsion, is so severe that Mackey argues it should really only be handled by the Grand Lodge.
He does. Because expulsion isn't just kicking a man out of his local lodge, it's Masonic death. It severs his connection to the entire universal fraternity. That's a decision, he argues, that should only be made by the supreme authority of the jurisdiction.
So we've journeyed through this incredibly detailed legal framework, a system built on centuries of tradition and these unchangeable rules, these ancient landmarks.
And it all seems to boil down to that requirement for a belief in God and the absolute demand for physical and moral perfection in his candidates.
It's this constant balancing act, isn't it? The absolute power of the Grand Master on one side.
And the absolute democratic power of that single black ball held by any member on the other. All of it designed to protect the moral purity and integrity of the group.
And what's so striking is how that moral and religious integrity is placed above everything else, even above loyalty to the state.
Which brings us to our final, provocative thought. It comes directly from the ancient charges themselves. The law is very clear. If a brother is a rebel against the state, if he commits treason, the other members must disown his rebellion. They must not support his treasonous acts. But, and this is the part that stops you in your tracks, they cannot expel him from the lodge for that political crime alone.
Wait, so a man who doesn't believe in God is barred forever. A man with a physical defect is barred forever. But a man who commits treason against his own country cannot be expelled for that reason alone.
That's what the law says. It tells you that in the eyes of the craft, your political allegiance is secondary. It's temporary. Your duty to the state is important, but it is not as foundational as your duty to the moral law and your belief in God. That moral religious bond is seen as more essential, more eternal than your civil obligations. And that tension between the laws of men and the unwritten laws of the fraternity is maybe the deepest and most challenging aspect of this entire system.